Hello. In my last few classes, I have taught you four main offenses relating to property, that is theft, extortion, robbery and dacoity. Today we are going to discuss about criminal misappropriation of property, criminal breach of trust. These offenses relate to wrongful retention of property. So let's first start with criminal misappropriation of property. Earlier, it was dealt in IPC also, and the section, the definition and the content of the section are almost same. Under Bharatiya Nyaya Sanhita, it has been dealt in section 314. The section says, whoever dishonestly misappropriates or converts to his own use any movable property. Okay, so only the movable property can be the subject matter of criminal misappropriation of property, shall be punished with imprisonment for a term which may extend to 2 years, with fine or both, but which shall not be less than 6 months. This is a bailable offence, so bail can be granted in this offence, and non-cognizable offence, triable by any magistrate. So, in this definition, we have seen that there are two important essentials of this definition. First is dishonest misappropriation of property. First is dishonestly misappropriating the property or converts to his own use. Converts to his own use. ठीक है? The property should be movable. Movable property. Okay. Such property must be movable. So the mens rea is in this offence is dishonesty. The dishonest misappropriation of property, as we all know that the two important elements of crime are mens rea. There are two important elements of crime. First is mens rea and second is actus reus. The mens rea in this offence is dishonest misappropriation of property. Okay. And the actus reus for this offence is conversion to its own use. Okay. So let me give you one illustration. Suppose X goes to his friend's house for birthday party and he finds a mobile phone there. So when X goes to his friend's house for birthday party, he saw a new mobile phone there, he picks it up, and if he transfers that phone to himself or he takes out his friend's SIM and inserts his own SIM, this is called misappropriation of property. Firstly, it is not necessary that at the time of picking up the property your intention was dishonest. Your intention might be innocent. There was no dishonest intention at the time you were moving the property. The dishonest may develop subsequently. So when he picks up that phone, his intention might not be dishonest, but seeing that phone, that this is a brand new iPhone, he developed dishonest intention and he inserts his own SIM and he starts using that phone. Then this is called criminal misappropriation of property. Okay. So for an offence under this section, it is not necessary that the property should be taken with dishonest intention. As I was telling you earlier, the possession of the property may come innocently, and then by subsequent change of intention, the retaining of that property becomes wrongful or fraudulent. There must be actual conversion of the thing misappropriated to the accused on use. Mere retaining of an article found does not amount to criminal misappropriation. Suppose this is a very costly pen, and in my school or in my college a annual day function is going on. I saw this pen lying on the ground and I pick it up. I am simply retaining this article that in the morning, or I will submit this article to the lost and found section in the assembly section, or in the morning in the assembly session. This is no offense. But if I take this pen with me and if I start using this pen as my own, this offense would amount to criminal misappropriation of property. Okay. Now let me give you another illustration. A takes his property belonging to Z out of Z's possession in good faith, believing at the time when he takes to himself A is not guilty of theft, but after discovering his mistake, dishonestly misappropriates this property, he should be guilty under this section. Suppose me and my friend, we have two pens. They both are of similar kind and similar color. I thought I took this pen from my friend and I thought that this was my pen. But later on it was discovered that this was his pen and not mine. But still, after discovering this fact, I started using this pen as my own. This thing was amount to criminal misappropriation of property. Another illustration. A and B being joint owners of a horse. A takes the horse out of B's possession, intending to use it. Here A has the right to use the horse. He does not honestly misappropriate it. But if A sells the horse and appropriates it and proceeds to his own use, he is guilty of this section. Suppose there is a horse and two persons are joint owners of it. They are free to use that horse. But one fine day, what A did, he sells that horse, and the amount which he received, he started using that amount to his own use. This would amount to criminal misappropriation of property. Okay. Similar is the case in there are few instances that there are certain properties in which there is no possession or ownership. And there is one explanation also. Like property which is in the possession of no one. There are certain properties, like if you see any note, any wallet, or any valuable item lying on high road and you pick up that item, no offense is there. But if in the wallet the suppose this wallet is lying on highway and inside this purse there are some currency notes, PAN card, Aadhaar card and other IDs which reasonably could lead to the address of the owner, without making any effort to discover the owner, because in Aadhaar card or in PAN card or in voter card the clear address is mentioned and you have means to discover the address of the owner and you can return that wallet to the owner. But in spite of this fact, X puts that wallet into his pocket and starts using the credit card or the currency notes for himself. This would amount to criminal misappropriation of property. But suppose if this is a 100, 500 or 200 rupees note lying on highway, is there any mean to ascertain the true owner of this note? Is there any possible way? Suppose this is a 500 rupee note and this is lying on highway. Is there any mean that one could possibly reach the owner through this note? No. So if in this case, if A picks up that note, no offense of criminal misappropriation would be there. Okay. So I have illustrated with few very basic example. Now let's understand the meaning of misappropriation and conversion. Misappropriate means to set apart for or assign to the wrong person or for a wrong use. Converts to his own use means to deal with the property as if one is the owner, as if one is the owner. As I have told you earlier, suppose I see this wallet or gold chain or any valuable item or anything or any iPad, and I know that this does not belong to me, and I start using this as my own. This is conversion. Okay. Now explanation to section 314. Criminal misappropriation includes temporary as well as permanent misappropriation of property. Okay. Second explanation, things which are abandoned, which I have told you earlier, things abandoned cannot be the subject matter of criminal misappropriation under this section. For constituting an offence under this section, the property appropriated must be owned by somebody. Okay, जैसे in हिंदी वैसे लावारिस वस्तु, तो that abandoned property और वो जो लावारिस वस्तु होती है, there cannot be any criminal misappropriation of that property, because after using all reasonable care and due diligence, the true owner of that property cannot be ascertained. This explanation requires finder of goods before appropriating the property found to make attempt to find the owner if they have means of doing so. So, if either it is a lonely road, it is midnight, it is highway, or it is a very busy street with hundreds of people there, and you find anything, any mobile phone, any iPad, any credit card or debit card or any wallet lying on the road or highway, first you must take all possible, you must make all possible efforts to ascertain and to find the true and real owner of that good or that property. In credit card, obviously, name is mentioned, Mr. X. In wallet, if there is Aadhaar card, PAN card or voter card, address is mentioned. So, first you should make all possible efforts to ascertain the owner. The finder must wait up to a reasonable time to allow the owner to claim the property before he appropriates it. Okay. Now, what would amount to criminal misappropriation? Suppose in Diwali shopping, it is a very busy street, and you saw one gold ring or gold chain lying on the road. Without making any effort, you immediately went to the goldsmith or to a gold shop and you sell it and use that proceeds to your own use. This would amount to criminal misappropriation of property, because without any second thought, you just sold that item. Okay, you didn't make any effort to ascertain the owner of that item. Or similarly, the currency notes on highway or wallet, this would come under this explanation. One thing you should also remember that there are certain cases, like in the case of currency note or in the case when the item is lying on or found on high road, that there are no possible means to find the owner. Okay, so a person who finds the lost property is not guilty of misappropriation if he takes steps to discover the owner, or if they believe in good faith that the owner cannot be found. If you saw a 100, 200 or 500 note lying on highway, this offence is committed only when they form a dishonest intention to keep the property after knowing or having the means to discover the owner. Like if in wallet the address is clearly in Aadhaar card or PAN card or voter card, the address is clearly mentioned. Okay? Another example which I have just told you, that if A finds a wallet on the road and if A immediately keeps that money with no intention of finding the owner, it is dishonest misappropriation. if A picks it up to find the owner, okay, you saw the wallet and you thought that when I'll return to my place, I'll make all possible to find the owner, but later decides to keep that money. The dishonesty begins at that moment. Okay. So in criminal misappropriation of property, in criminal misappropriation of property, the whoever dishonestly misappropriates or converts to his own use, okay, any movable property, that would amount to criminal misappropriation of property. Now the next topic, criminal breach of trust. It is dealt in section 316 of Bharatiya Nyaya Sanhita. Whoever, section 316 of Bharatiya Nyaya Sanhita defines criminal breach of trust. It says, whoever entrusted with a property or dominion over a property. Dominion means authority, supervision, kind of supervision. Whoever entrusted with a property or dominion over a property dishonestly misappropriates or converts to his own use that property in violation of any direction of law prescribing the mood in which trust is to be discharged or any contract, express or implied, which he has made, or willfully suffers any person to do so, commits criminal breach of trust. Okay. So, what are the essential ingredients of this offense? First is entrustment of property or dominion over property. Entrustment. Entrustment means the trust, the faith, the belief. Dishonest misappropriation, conversion, use, or disposal of that property. And the act must be in violation of a legal direction or contract. Let me give you a very simple illustration. Suppose I am going to UK for vacations and I have a car. I handed over that car to my friend that I am going to UK for 2 months and you just take care of this vehicle. Now what he did, he registered my vehicle with Uber or Ola in violation of my direction. And whatever the profit was coming from that Ola and Uber company, he starts using that money for its own use. So first condition, I entrusted that property to my friend because we both share a faith. There was trust that he will take care of my car, he will not do anything which violates my direction. But what he did, he violated my direction and he dishonestly misappropriates that car for his own use. He starts making profit from that car. So this would amount to criminal breach of trust. Okay. So first essential says entrustment of property or dominion over property. If a property is delivered to another person out of trust and that person dishonestly converts the property for his own use, he commits the offense of criminal breach of trust. Okay. As I was saying, suppose if A entrusts his watch to B for 2 days, but B dishonestly converts the watch to his own use, here B has committed the offense of criminal breach of trust. Second point, the BNS does not specifically provide the type of property. So both the property which is movable and immovable are subject matter of this offense. For criminal breach of trust, there has to be a relationship of trust and faith between two persons. And also it is not necessary that they should have known each other for a long period of time, because the faith can develop at the moment also. Okay. It may develop even on the spot. The property should have been entrusted by the owner to the accused, and the victim, while entrusting the property, should have given up the possession of property. That is abdication. Abdication means while I was going for my vacations to UK, I had given up the possession of my vehicle to my friend. there was no actual or constructive possession of the car with me. He was having the key, the car was in his garage, and he started using that vehicle for his own use. He registered that vehicle with Ola or Uber, and he started that vehicle for his own use. I was not having any kind of possession. So the owner or possessor, firstly what he has to do, he should part with the any kind of possession or custody of the property. Okay, there should be no actual or constructive possession of the property. The person should no longer be in possession of that property. For application of this section, there must be an entrustment of property. An entrustment means handling over the possession of property for some purpose, which may not imply the conferring of any propriety rights. To constitute the offence under this section, there must be dishonest misappropriation by a person in whom confidence is placed as to the custody or management of the property, and he breaks that faith and confidence. Okay, another example. Suppose a bus conductor, they are authorized to collect money, okay, and they should render accounts to their respective state transport corporation. Now one conductor, this is a famous case also, one conductor, he used to collect the fare, the ticket, without rendering the account to the transport corporation. Okay, so he was held liable for criminal breach of trust. Second essential, dominion over property. Dominion means authority, the supervision. So for an offence under this section, either the property must have been entrusted to the accused or he must have dominion over it. A person is said to be having dominion over property when he supervises or exercises control over the property or is in the charge of that property. Basically, it is authority. Am I in a position to still exercise the authority from UK to my friend? He was using that car. So dominion basically means this. Okay. There are few cases on this point. First is Ram Naren Popli versus CBI, Central Bureau of Investigation. This is a 2003 case. In this case, the court held that the entrustment of any property means handing over the possession of the property for some purpose that may not infer the proprietary rights. Second case, in Rashmi Kumar versus Mahesh Kumar Bhada, this is a 1996 case. In this case, the Supreme Court held that when the wife is entrusted with her Stridhan property and gives the authority here means the dominion to her husband or any other member of the family. Any other member of the family means the member of the husband's family. In such a case, if her husband or any other member of the family dishonestly misappropriated the property for their own use, the husband or other family member commits the offense of criminal breach of trust. Another case, R.K. Dalmia versus Delhi administration. In this case, the court held that if the partners are entrusted with some property and if they misappropriate the property for their own use, they commit the offense of criminal breach of trust. Okay. Let me give you another illustration. Suppose there is a priest of a temple, and in temple various kinds of offerings are there, and that offering should be used for the benefit of the temple only. And if the priest starts using that money or that offerings to his own use, then this case would come under criminal breach of trust. Okay. Similarly, government official who are authorized to receive money on behalf of government uses that money for their own use. Okay. This is criminal misappropriation of property. So section 316 deals with criminal breach of trust. There are two more illustrations for better understanding. Suppose there is an executor and he was directed by the person that after my death, you are this, I am writing this will, and you have to give this portion, this portion, this portion equally to my three sons, 33%, 33%, 33%. And what executor did? He took the share of one son. He started using the portion of one son to his own use. This is criminal breach of trust. Okay. Punishment is given in clause 2 of 316. There is punishment is imprisonment up to 5 years or fine or both. Punishment when there is a case of criminal breach by a carrier. This is dealt in clause 3 of section 316. The imprisonment may extend to 7 years and shall also be liable to fine. When criminal breach of trust is done by clerk or servant, this case would fall under clause 4 of section 316. The imprisonment is up to 7 years and the person shall also be liable for fine. When criminal breach of trust is done by public servant or by any banker or any merchant or agent, this situation is dealt in clause 5 of section 316. The imprisonment may extend to life or to 10 years and that person shall also be liable to pay fine. Now, there are two cases in this. Apart from those cases, Keshav Chandra Boral versus Nityanand Vishwas. It was held a user of property comes within this definition when such user causes substantial or appreciable loss to the owner of the property gained or accused. Okay. Second case, Govardhan Chandra Mondal versus Kanai Lal Mondal. Violation of a contract in order to amount to criminal breach of trust has to be in respect of legal or valid contract and not one of the criminal purpose. It means the direction or the terms of the contract, they should be legal. Now the difference between criminal misappropriation versus criminal breach of trust. Criminal misappropriation is dealt in 314 and 316 of Bharatiya Nyaya Sanhita deals with criminal breach of trust. Firstly, the possession. First criteria of difference is initial possession. It is not necessary that property must be taken dishonestly only. In criminal misappropriation, the possession may also come innocently or by finding. But in criminal breach of trust, the property is acquired through a specific act of entrustment by the owner. Relationship. No prior relationship of trust is required. But in criminal breach of trust, the two parties, there is a mutual trust, a prior fiduciary relationship, example of employer-employee, agent, principal and bailer-bailee is required. It is the foundation of this offense. Nature of offense. Dishonest conversion of property that was not entrusted. In criminal breach of trust, dishonest conversion and breach of a pre-existing trust. Okay, because the property is entrusted, the property is given by the owner. Examples I have told you, finding a lost phone and you decide to keep it and you start using it. And in criminal breach of trust, you are authorized to collect money on behalf of government and you start using the proceeds for your own use. Thank you very much. With this, I